Good afternoon, everyone. My name is Darren Sall. I'm your employment lawyer today on today's live question and answer session. I'm here for employment and disability law. Bring you greetings from somewhat gloomy Vancouver today. So hello to everyone in BC, Alberta, and Ontario. I hope you're having better weather than we are over here. Like I said, I'm your associate today, Samfiru Tumarkin's 30-minute question and answer session. I'm here to answer all your questions, employment and disability law related. There's no questions too small to ask on the channel here, and then there may be a couple questions that are too big, but feel free to reach out. If you are bashful or if you have private information that you are not wanting to ask something live on the air, you can see in the bottom left corner, we'll have some contact details thrown up, and they'll be coming out throughout the show. But you can start off emailing us at help@employmentlawyer.ca. Your information is always confidential. Send it in to us. Someone from our wonderful intake team will contact you to book a consultation with either myself, one of my colleagues, depending on what jurisdiction you're in. I myself practice in BC and Alberta, so feel free to reach out. You can go on our website and employmentlawyer.ca. It's popped up on the bottom there again, and click on any one of our links. You see someone you want to talk to, or you want to get my contact details, feel free to pop on there. And again, my QR code and my details will pop up on the screen throughout the show. But while we wait for some questions to come in here, I've got a couple things I want to talk to people about, just things I've seen in my practice, things that have been kind of going on in employment law and disability law, kind of trends lately, if we can even call it that. One of the biggest things is industry layoffs. So large layoffs, companies recently, I believe, PepsiCo, Rona, 123 Dentist, they all announced staff cuts. We've had Spotify, we've had a number of companies in the tech industry specifically have been laying off huge swaths of their workforce. And I've had people just call in to say, like, listen, I was laid off with 30 other people or 20 other people. We're all in the same general field. I'm worried about my ability to find work, and this is the severance package I was offered. What can I do? And it's a great question, and I tell everyone who calls in and asks me that, and I'll tell everyone here, the first step, the best thing you can do, give an employment lawyer a call. Give an employment lawyer a call to review your package, to discuss your situation. Once you've been terminated, definitely. But also if you feel like you're going to be terminated. And this is something that I think not enough people take advantage of, which is if you are experiencing some issues at work that you don't know how to navigate, whether it be, bullying and harassment, whether it be, interpersonal conflicts with a coworker or with a superior or with a subordinate. Give us a call, run through your scenario with us and let us give you some advice, to make sure you get that advice, to make sure you don't run into an issue where, you could have done something differently and say saved yourself or your company a hassle. Call in, get some advice. We do consultations, even if you're not terminated. We handle all facets of employment law. And so that's something that, I always want to make sure people are aware of. And many people I talk to, when they say, well, I was just terminated and this information would have been, nice to know before. And when I tell them, give us a call. I talk to many people, before they're terminated. Weeks and months, they say, oh, things are going not that great at work. Things have been going downhill lately. Performance, I've been put on performance improvement plans. What can I do? And I help guide some of these people either through to their termination to make sure their rights are respected and that they are afforded their full entitlements, or to help them turn things around at work and to really navigate things with their employer to get past the rough patch, let's call it, and get back into their employment and get their employment back into good standing. So I think if you're worried about a possible termination, if you're worried about conflicts at work or issues you're going through at work, or if you just have general employment questions, you're looking to approach your employer for a raise, and you're unsure how that is going to go, and you want to protect yourself, or you're wondering if you can be terminated for that, give us a call. Happy to chat about it. So we got a couple questions that have come in here. We have a question from YouTube, from ABS 57051. ABS asks, I just signed a 5-year no client soliciting or no information sharing. I want to start my own company in 2 to 3 years. Should I be worried? So ABS is I mean, I have to know a little more about the context in which you signed this, and as well as the wording. So, I'll give you some general advice here, but I think what you'd want to do is get a copy of what you signed, give us a call, send it in, and happy to review that with you. For non-solicits, for confidentiality agreements, the devil's in the details. The specific wording of the clause of the contract is always extremely important. It can mean the difference between an enforceable provision and a non-enforceable provision. There's also things like consideration. For example, if you're not given anything for signing away a number of rights, or a new contract, that may not be enforceable. That may not be an enforceable agreement. And so I would say, definitely reach out, especially given the fact that you're wanting to start your own company, and it looks like within that 5-year period. I mean, on its face, a 5-year period right now to me feels pretty unenforceable. The courts are generally loath to impose lengthy or onerous obligations on employees leaving a company. That being said, I'd have to know more about your particular situation, how your employment came to an end, what led to this type of an agreement being signed, and whether or not you received anything in exchange for it, if it was a mutually negotiated term or whatnot. But, so there's a chance it could be enforceable. But I think if you're already looking at starting your own company in 2 to 3 years, and I'm just going to assume based on the question that this company would be either engaged in the same industry or work as your former employer, and or would have an overlap in clients and would potentially be, cannibalizing business from that former employer. And that's why it's a concern. And so, again, ABS, I think reach out. Happy to take a look at that. A number of us would be happy to take a look at that and review it for you. And give you a little more tailored advice. So you can go to employmentlawyer.ca, reach out to one of us. Our intake team will be happy to connect you with one of the employment lawyers in whatever jurisdiction that you're in. Myself, if you're in BC and Alberta, I'm happy to speak to you. If you're in Ontario, one of my colleagues out there. And we'll be able to give you a little more tailored advice. So we have another question through YouTube from Lance. Lance asks, what can I do? Home City ICE uses illegal immigrants to bag ICE in their South Bend, Indiana, and Crown Point, Indiana locations, probably more. I just don't know what I can do. So, I mean, if you're talking about Indiana and in the U.S., I mean, unfortunately, I won't be able to give you too much advice on that or any advice on that. I don't practice in the States. And so I'm not aware of Indiana employment law, and moreover, of the immigration laws out there and how those interact. So I would say reach out to a local agency, or you can reach out to, I think, local law enforcement if you have a concern, or local employment lawyers in your state to discuss that further. Sorry, Lance, it couldn't be of more assistance, but thanks for watching. And if you have any other questions, feel free to jump in. We got another question through YouTube here. Okay, YouTube's busy today. This is from Belinda Beguiling. Belinda, thank you for your question. Belinda's question is, I've started working for a magazine company in the US as an editor and marketer. They keep telling me I am working at will, but I have not signed a contract and never agreed to this. Is this true? So, Belinda, I'm going to assume you're working in BC. And unless that the company's based in the US and you're doing editing and marketing services perhaps in Canada, that's what I'll be able to you do live in Canada. Okay, perfect. So with respect to this, your employment will be governed by the laws of Canada, the laws in which the province you live. For example, if you're working out of BC, they'll be governed by the BC Employment Standards Act, and you'll be subject to BC, especially because you don't have a signed contract. you'll be subject to BC laws, as that's where you're performing services and whatnot. At-will employment is a U.S. term. I've come across it many times. I've dealt with U.S. companies very frequently. And at-will U.S. Employment is a U.S. term. And essentially what it means out there is kind of what it means out in BC, is that an employer can fire you for whatever reason, as long as it's not, for example, in BC, if it's not discriminatory and it's not a human rights violation, or they're not firing you because of a reprisal or something that's protected by work-safe legislation. In BC, an employer can fire you as long as it doesn't fall into any of those prohibited categories. An employer can fire you and for any reason, as long as they pay you severance, as long as they pay you your severance pay. And in the States, it does work differently in different states. There are some states that don't have severance pay. There are some states that just say your employer can fire you for any reason at all, I've seen. And there are laws in certain states. I mean, I'm not going to go through all of them where, even some human rights categories are not protected. And so the U.S. employer and having dealt with U.S. employers quite a bit with respect to their Canadian employees or services that are provided through Canadian employees or even Canadian contractors, the U.S. companies often approach these situations with the misapprehension about what their obligations are and what their liabilities are. And so, Belinda, I think you should make this very clear. I think if you want, reach out for a consultation. I mean, I'd be happy to speak to you just about this issue because it is quite a niche issue. It's a very specialized issue, looking at your relationship with them, anything you may have signed, or any agreements you may have made when accepting employment, an offer letter, perhaps. You can feel free. You can scan the QR code in the corner, and I'm happy to set up a call with you to chat with you about this. But generally, even if your American employer terminates your employment, they're still going to owe you severance. And I can say I've successfully gone after that with U.S. employers. And a lot of the times it's just they're under a misapprehension of the law that applies in Canada because they're only aware of the U.S. employment law. And they just haven't taken the time to, perhaps hire a lawyer out here and educate themselves as to Canadian employment law. Maybe it's not cost effective. They don't have enough employees out here to worry about it. But yeah, Belinda, just because you're working for a U.S. employer, working out of Canada, providing services in Canada. I mean, I'm unsure if the magazine company operates in Canada. I'm going to assume they do. And so if you're also, the products here in Canada, I mean, you're pretty firmly entrenched here. So you would have the protections of the Employment Standards Act. You would also have the protections of common law notice out here. And so, I wouldn't worry about that too much. But please do reach out. I'd like to get more facts and more specific information, or to give you more tailored advice. All right. Hopefully that answers your question enough, Belinda, that you're not worried about that. Okay, and so we have another question through YouTube. And this is from Empress. Empress asks, I work for a large car rental company, and for the last 2 years, my commission has been much less than it should have been. Is this legal? I'm supposed to receive 4%. So, Empress, I think it depends on the reason that your commission has been less. If it's just been due to a lack of sales, I know the car industry, the automobile sale industry has been hit quite a bit with COVID, chip shortages, and with car shortages, I think generally. And so, if that's the reason that your commission has been reduced, that there's not a whole lot you can do about that. I think you're feeling the squeeze of the market. If reading your question, it sounds like you should be receiving 4% of whatever sales or however your commission is calculated, and it sounds like you may be receiving less than that. And so if you're receiving less than, if you've agreed with your employer that your salary or your remuneration is based on a salary of X, and then you get a commission of 4% on some formula, and you're now getting paid 3% or 2% or 1% based on that formula, you're not getting your full 4% that you agreed upon. That could be the basis for a constructive dismissal. The reasoning behind here really matters. And I think the other thing that really matters is the amounts. mean, if we're talking about a difference of 1 to 2 to 5% of your pay, or even 10% of your pay, that may not be enough or significant enough to trigger a constructive dismissal. If you're receiving 1% of your commissions, and that equates to, because I know I've helped a lot of people in the car industry, and I know the commissions can outstrip your whatever base salary or draw you're given by 3, 4, 5 times sometimes. And so, if the commission change, if they're only giving you 1% of your commissions, let's say, and this results in a 50% change or drop in your income, then I think you're going to have a great case for constructive dismissal. But again, constructive dismissals are very, very fact-specific scenarios. Essentially, what it is you're telling your employer by unilaterally changing your employment contract, they've repudiated the agreement by doing this, and they've effectively terminated your employment. It is a very fact-specific scenario, and I tell everyone, don't throw the term around casually. If you think you're in a situation where your employment, key and core concepts and terms of your employment have been changed, or are talking about being changed, sometimes these come out of nowhere, but sometimes the employer will come to you and say, listen, economic downturn, can we drop your commissions by 2%? Otherwise, we're going to have to let you go. Some people may agree to that on a limited basis. Fine. That wouldn't be a constructive. But if the employer just comes to you and says, listen, economic downturn, we're dropping your commissions to 1% now, and you're now going to make, where you used to make $200,000, you're now going to make $75,000. You don't have to accept that. And that would, likely ground a claim for a constructive dismissal. But if you're in a situation like that, or your employer has approached you about a situation like that, or you have concerns about a situation like that, please reach out immediately before anything happens, before you say anything to your employer. If your employer does come to you, before you respond to your employer, always a good idea to hop on the horn and get some legal advice, just to make sure that you set up your claim in the most successful way possible, and the way that protects your rights best. Okay, so Empress, I hope that kind of gives you a somewhat of an answer, or at least a structure with which to approach kind of the coming days, and please do reach out. I'll be happy to speak with you. And so we got another question from YouTube, from Rackle. Rackle asks, if your employer terminates your position while you're on LTD, does this impact your coverage? And so Rackle, no, your coverage, if you're on an existing LTD claim and you're terminated, your coverage will stay in place. Your claim will stay in place. You will no longer have LTD coverage moving forward. So, the terms, I'm not sure if you're using the terms in the intended way, or if that's just you're using it to describe your claim. So if you go on LTD, and let's say in long-term disability, and say January of 2023, and you're approved and everything's going along fine, and in April your employer terminates your position, and your existing LTD claim, you would stay on LTD. What it would mean, though, is if you are off LTD at some point and you're able to go back to work, and LTD finishes, but then you get disabled 6 months after your LTD finishes, you won't have coverage for a new claim. Okay, and so if you have an existing claim, or you've been denied, and as long as you've gone through the application process and everything appropriately while you were employed, and while you have that coverage in place, your coverage for LTD shouldn't be interrupted. But if you are terminated before you apply for the LTD, so let's say you become disabled, or you're not disabled, you're terminated, and then you're disabled a week or two later, arguably you won't have LTD coverage. Sometimes they can extend coverage through a notice period, but those are very fact-specific situations. And so, Rackle, if you have an issue where you have a coverage dispute with either LTD, your LTD insurer, or with your employer, please do reach out. We'll be happy to speak to you. Those can be very tricky situations. And a lot of the times it will depend on what information the parties had at the time, and what your specific terms of coverage are, really, at the end of the day. All right. So we have another question here, again through YouTube, from Gassan. Gassan asks, if my workers' compensation, I think it means IME doctor said I cannot do my regular job duties, and in this case, can LTD disability insurance force me to work? Thank you. So, Gaston, it really depends on a number of factors. If your I'm assuming you're on WCB and LTD, it seems like. And so if there's an IME, so an independent medical exam, which is something that WorkSafe can send you to if you're on WorkSafe benefits, and it is something that your LTD insurer can also send you to determine whether or not, what they do is they send you to a specialized doctor who will write them a report with knowledge of what your job duties are and what your medical condition is, and will typically examine you or at least interview you and review all the notes, and they'll let the insurer know whether or not you're able to return to your existing job. And if you can't return to your existing job, which it seems like, Hassan, you cannot, they will list out potential jobs you could do. And now LTD can say, well, because you can go back to work, there's various stages in the claim. There's typically for most claims, it's a short-term period, and then there's the first 2 years you're on disability, which is you are disabled from doing your own occupation. And then after those 2 years, typically, you will go into what's called the any occupation phase, which means that you are disabled from doing any occupation for which you have training and education for, or commensurate, training and education for, and you can't do any job like that. Now, if the IME says, well, yes, you're in the any occupation phase, and you can do another type of work. I always tell people, go to your doctor, speak to your treatment professionals as well, and see if they agree. And if they don't, give us a call. And in any event, if your insurer or workers' compensation is sending you for IMEs and trying to force you back to work or trying to force you off coverage, then I would say, please do give us a call, because that can be a very tricky interaction. That can be, there's going to be arguments on both sides that need to be carefully considered. And there is a chance that if all of the treatment professionals kind of line up and say, yes, you can do something, you may have to at least attempt it, right? And if you attempt it and can't do it, then there's provisions in which your disability and LTD can come back into play. But again, this is a very, very specific situation for each claim. There are really no two claims that are similar. So this is more just general advice on that, is if you are in a situation like that, typically you have an obligation to go to the IME, and then I would say, contact us and let us talk to you and help you with that. Okay. And now we have another question, again through YouTube. YouTube's busy today, I guess. From JR. JR asks, what proper line of communication should a prospective job seeker keep while maintaining a potential contract position? So JR, I'm not quite sure I understand your question. Yeah, I think, JR, I may need some more information. I'm not quite sure what you're trying to ask here. What proper line of communication should a prospective job seeker keep while maintaining a potential contract position? Yeah, I think, JR, sorry, I'm going to need a little more information. I mean, I'm always a proponent of written communication, because it really does allow the parties to iron out any misunderstandings or anything like that, as to terms, as to specifics of contracts or whatnot. It really does let them iron it out, in real time between each other, while giving each party a chance to kind of think about it. You're not relying on recollection at a later date to, bookend your contract or your agreement or terms that the parties have agreed to. So, I always say email is the best thing to do. And again, JR, if you can provide some more context, then that would be great. And I'm happy to give you a more detailed answer here. But I'm going to pop over here to a question through Facebook from Ramola. Ramola asks, what if you suffer from a condition you think stemmed from a mental workplace injury? WSIB approved you, but now you are appealing a disability payout. Disability impairment is permanent. Doctors have provided info on your current health, but not enough to certify the physical disability is connected to the mental injury. That's really specific. Ramola, I think if you have, it sounds like you were approved for the physical injury to WSIB, and there is a disability impairment coming, rating at least coming from that, and a payout coming from the physical injury, but you're now saying that you're also saying that there's a mental component as well that should be included in this. And I think, I mean, from what it sounds like, if that's correct, if what I've said is correct, from what it sounds like here is you're doing the right thing. You're appealing the decision. I think you need to speak to your doctor about sorry, well, okay, you just said mental injury is approved. And so, okay, if you've been approved for the, so if you've been approved for the mental injury and you're getting a permanent impairment payout for that, and your doctor has not been able to certify the physical disability is connected to that, I think you need to talk to your doctor. I think you have to appeal and you have to talk to your doctor and see whether or not your doctor can write something a little more tailored, and whether that's their opinion. And if that's their opinion, depending on what jurisdiction you're in, if you're in Alberta or BC, I mean, you wouldn't be in BC with WSIB. I think you're either in Alberta or Ontario. And so I would say you can reach out to us, and when we can take a look at it, and we do have people who have done work safe matters before, and we do practice in that area generally. Ontario, okay, and so you can reach out to someone in Ontario, and I mean, if we can't help you, there's always a chance we can refer you to someone who can help you. But I think you're doing the right thing. In any, like, if you look at this like an LTD issue as well, I mean, I've done this in the past before, where you have a multitude of injuries and only one or two are, say, approved, but you need the rest of them to be kind of lumped in, and your doctor thinks that they're part of it, and you can fight that, and you're doing the right thing. You're appealing it. And I think what you have to, what you always want to make sure you do with an appeal, especially with the WSIB appeal, is to get new information. I think, what a lot of people do is they simply ask that same body to reconsider their decision based on the exact same information. And I tell people, you're asking one person to make the same decision again, but a different decision based on no further data. It's likely not going to go in the way that you want it to go. And so talk to your doctor, really explain to your doctor. I always say, get an in-person appointment, sit down with them, explain to them your thoughts on the matter, and see if they can write you an opinion that supports that. And if they do support your position, sometimes as doctors just don't think that far ahead. They're only focused on the medical, not on the benefit side of this, right? And so have that talk with them to say, listen, this is why this is important. This is why I think this is connected. Can you credibly and realistically say, is this connected? Can you give that opinion? And if your doctor can, get that note, get that report, send that in, and have them review it there. And if not, you can talk to a lawyer, and we can help you with what your doctor would need to say, what the contents of an appeal should look like, and we can definitely assist you with something like that. And so we have time for about 10 seconds left here. So we have another question here from YouTube from Big T. And I'm going to end off with you because I like the name. So Big T asks, what happens after you have had a discovery assessment done? So in the litigation process, after you've had an examination for discovery, I'm assuming that's what you're talking about here, it's the same in almost every type of claim. There are nuances between long-term disability and employment claims, but generally after you've had an examination for discovery, the parties will talk and you'll see what information comes out. There'll be a further exchange of documents. There may be a second examination depending on the information that comes out and the peculiarities of your case. And generally that's the last big milestone before heading into a trial. So, if you're at the stage we've had a discovery, I would say talk to your lawyer about the timeline they're looking at. Again, every case is different. Some cases they just need a discovery to settle or to resolve because the other party needs documents or information. And so that's just, it's a milestone in a legal claim. And if you hit that, the next big milestone would just be trial. So thank you for all the questions today, everyone. Again, I'm Darren Sall. I'm your employment lawyer out of BC, and I practice in Alberta as well. Feel free to reach out to me or any of my colleagues. If you enjoyed today's session, found it useful, tell your friends. You can hit like, you can subscribe, you can pass this on to anyone else you think may benefit from it. And reach out to us in real time. I'm always happy to talk with people and talk through their situations. That's it for me today, but we'll be back on June 21st with Lior Samfiru at 1 p.m. Eastern time for the employment law question and answer session. So feel free to reach out to any of us, and thank you for joining us today. Appreciate it, and everyone have a great day.